Trademark myths and the importance of trademark registration for e-commerce businesses. 1. Differences between trademarks, copyrights, and patents. Before we discuss trademark myths, let's explain the differences between patents, trademarks, and copyrights, as business owners often confuse them. Copyright is a legal protection given to original creative works such as books, photographs, art, movies, and music. It grants the creator exclusive rights to reproduce, distribute, display, make derivatives of, and perform their work. Generally, copyright protection lasts for the life of the author plus an additional 70 years. For an anonymous work, a pseudonymous work, or a work made for hire, the copyright endures for a term of 95 years from the year of its first publication, or a term of 120 years from the year of its creation, whichever expires first. A patent, on the other hand, protects inventions and innovations. It grants the inventor exclusive rights to their invention, preventing others from making, using, selling, or importing it without permission. Patents can cover processes, machines, manufactures, compositions of matter, or improvements thereof. Patent protection typically lasts for 20 years from the filing date. A trademark is a form of intellectual property that protects brands from counterfeiters and helps consumers identify and distinguish goods and services from one another. It can be a word, phrase, symbol, sound, or design that represents the source of the goods or services. Trademarks provide their owners with exclusive rights to use the mark in connection with specific goods or services and can be renewed indefinitely as long as they are properly maintained. Trademark protection ensures that consumers can trust the quality and reputation associated with a particular brand. In sum, trademarks protect brands, copyright protects creative content, and patents protect inventions. 2. When should you apply to register your trademark? Many startups and entrepreneurs mistakenly believe that forming a company as an LLC or corporation automatically trademarks and protects their business name. Wrong. Operating under a company name, rather than your own, potentially shields you from personal liability for lawsuits. So, your company would be responsible for settling the lawsuit and not you personally. However, this does not protect your company from being liable for trademark infringement if it uses someone else's name or logo without permission. And if your trademark is in the company's name and your company is sued and loses, you could also lose ownership of your mark. Before you apply to register a trademark, you should perform due diligence, which involves searching for other marks that may resemble yours in connection with goods and services related to the products associated with your mark. Performing a proper trademark search is crucial because it can help you avoid the costly mistakes of spending time, resources, and money on a name that you were never able to use. After all, someone else had been using it before you. The failure to conduct a proper search can be a devastating mistake, forcing you to rebrand and start from scratch. And that may not be the worst part. You could be sued for thousands or even millions of dollars. This nightmare could possibly be avoided by hiring a trademark service to perform a comprehensive search. You should apply to register your trademark as soon as practical, but certainly prior to launching your brand. Before you start mentioning your brand on social media or to others not involved with your company, spending money on merchandise and apparel bearing the mark, buying signage, or building a website that mention the mark, or engaging in any financial transactions related to the mark, including signing a commercial lease, you should have already submitted your trademark application to the trademark office for processing.